Amanda, good morning. How are you?
Good morning, John. Well, Happy New Year, I guess we should
Happy New
say.
Year. Yes, we're still here on Thursday, the 22nd of January. So I think my rule is until the end of January. It's okay to wish everyone a Happy New Year. Do you have a good Christmas and New Year?
Yes, I had a great break and back refreshed and ready and yeah, excited for what this year's going to bring.
Yeah, and it's a very interesting year ahead of us, and that's what we're going to talk about for our listeners this morning. We're going to talk about the Employment Rights Act, which got Royal Assent actually on my birthday, the 16th of December. And so it is now an act of Parliament, and it is going to come into effect, and it is going to result in, during the course of this year and next year, the most radical change in employment law. And people have been saying for actually 25 years. I think it's in my lifetime, certainly since the early 70s, which is just about in my lifetime, but there we go. Um, but it is a bigger change than anything the Blair government did,
Yeah.
when certainly I was politically active then. And this is a bigger change than that. And so how do you think employers are feeling about the year ahead, Amanda?
Look, I think generally there is definitely optimism, and I think there's definitely growth. I can see lots of green shoots coming out this year already. With regard to the EBA, I think there is some uncertainty. I think many of them haven't really got their head round what they need to do going forward, and are a little bit in a flappy stage. That's my sense. So I hope this podcast can give some really good advice and some clear kind of techniques and ways forward for them, particularly with regard to the unfair dismissal change and the cap removal. So I believe this is a truly important episode of this podcast.
Yeah, and so let's try and deal with the uncertainty now, because I think you're right. There is some confusion still, some uncertainty. I'll give a brief overview now of what the main change of the Employment Rights Act. If I can speak for 2 or 3 minutes on that, I'm really interested in your international perspective and how we think that UK PLC still benchmarks after this against our international friends and competitors. But by far the biggest change is the change to the unfair dismissal qualifying limit, because it was a Labour Party manifesto commitment that it was going to be a day one right, and they flexed on that in the second week of December last year, and the flexing on that enabled the act to come into effect. And so we are now going to have, effective the 1st of January 2027, so we've still got a year to get ready for that, but there's a sting in the tail, listener, that there is going to be a 6-month qualifying limit for unfair dismissal. That will be the lowest it's been since, I think, 1974, since the mid-70s. It's gone up to 2 years under Margaret Thatcher's government. It went down to 1 year under Tony Blair's government. It then went back up to 2 years under the Conservative Party's manifesto commitments. And it's now coming down to 6 months. So one issue is that I think the qualifying limit for unfair dismissal has almost become a totemic political issue in this country about, are you pro-worker or are you or are you pro employer?
Yeah.
And the other thing, which is potentially more radical, and I'm really interested in your view on this, is the removal of the cap for unfair dismissal, which is currently 1 year's pay or 118,000. But it has meant that in a lot of unfair dismissal cases, bigger earners don't grieve or claim unfair dismissal because they're earning far more than 118,000, and in the city, etc., it's not worth them doing that. And so employment lawyers would say that for years, perhaps decades, that has meant other claims being developed on the back of that. So you sometimes see specious or legitimate discrimination claims, particularly whistleblowing claims for pale, stale males who don't have a route to breaking through the cap for unfair dismissal. Presumably you've seen that during your career, Amanda?
Absolutely, and and employees have been left in that kind of limbo period, and had to put let's say a more meatier set of evidence points together to be able to break that cap and to get something meaningful for the year that they've worked there. So I'm totally in line with you on that. I think it led to um, uh, 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 a behavior that was not required. So I think we have to now um, be thankful there's a change here, but there's definitely some nuances to this.
There's greater clarity, but it will make unfair dismissal claims much more prevalent, particularly amongst higher earners, and much more relevant. They will become, I think, again, the main claims in employment law, whereas often they were not the main claims. Discrimination claims were the main claims, or whistleblowing claims
Exactly.
were the main claims. And often those claims became more personal because you can sue an individual for discrimination. You can sue an individual for whistleblowing. You can sue your boss for whistleblowing, for
Right. Yeah.
whistleblowing detriment. You can't sue an individual for unfair dismissal. So it will make it a more kind of binary clash between employee and employer. Again, at least that's my sense as a result of these changes.
Yeah. Yeah. Look, I think it's a risk, but I will say this gently. I think it only increases the risk if we weren't managing well in the first place. And
Yes.
I think for good employers, it's a nudge towards better leadership and onto something that is now focused really on how you manage employees from day one. And I think the removal of the cap, John, which I know we'll go on to, adds even more pressure because it turns poor management into a balance sheet issue, basically, a balance sheet consequence, because boards will have to start caring about management and leadership capability in the ways that they haven't really bothered before, frankly.
And I think that's right. And look, one of our insights in this podcast, we hope that it is insightful for our listeners, is that people think, okay, well, this is the 1st of January 2027, don't really need to listen about this. And we have a dial-in call every Monday midday at Constantine Law. And one of our partners there made a really insightful observation saying that, no, this is becoming a now issue.
Yeah,
And if you're lucky enough to listen to this podcast, then you get an advantage on many of your HR peers because it's a now issue or becoming a now issue. If you're, in effect, it applies to anyone who's employed from the 1st of July 2026, doesn't it? Because there's
yeah,
6 months continuity of employment. So if you recruit the wrong person from that date, to your point, you're going to have to performance manage them, and you're going to and it becomes a balance sheet issue. But that person who may be employed from the 1st of July 2026 is on a notice period, and you're probably going to be looking at recruiting them in February or March this year.
exactly.
So this is becoming an issue for the next few weeks and certainly couple of months, where the risk that is associated with this massive employment law change might manifest itself now. So this is becoming a resourcing issue now. You agree?
That's right. Yes, definitely. And as I see, there's definitely more activity in the market. Hiring seems to be back, and I think that this now needs to really be quite focused on how employees are choosing employees, and how they're recruiting and their selection process. But I think if we talk about the first 6 months, John, of any new job, it's basically onboarding. Let's face it. I
Yeah.
always tell employees throughout my career, when you bring in a new hire, senior or junior, it
Yeah.
takes a good 4 or 5 months to get to know what you're doing, basically. And if we're honest, most managers kind of know by month two whether this thing is landing or not. And I think we want to be able to give the benefit of the doubt, but it's quite what I've seen in my career. It's much easier for that line manager to avoid the conversation, having the conversation, and that's going to have to change. But why do managers avoid having those conversations early on? Well, there's lots of reasons. Firstly, it takes quite a bit of courage. Secondly, you want to give people a bit of time to, maybe change into or develop and adapt to the culture. And, I think there was a report in Harvard some years ago which showed that there's a real fear of legal risk demographic or potential other type of lens, which actually makes managers delay conversations. So the exact opposite of what good practice now demands. So we see that as well. But I also want to reframe this, because this kind of making sure that you're checking in each month with the individual, having a proper audit trail, identifying ticking time bombs early, it's not just about covering yourself as a line manager. I think it's about being fair to the employee. People don't fear feedback, they fear the surprise. And we've talked about
Yes,
this on
that's absolutely true.
the appraisal podcast before. So I think early clarity is the most humane option here.
That's absolutely going to become a business requisite now, isn't it? That you
Yeah.
can't, employers will not be able to defer or balk at having those difficult conversations. If you think you've got the wrong person in situ after 2 or 3 months, you're going to have that conversation. And I think that it is going to mean that some contracts are going to have to be rewritten, because a lot of employers have probationary periods that last for 6 months. I think now they're going to have to last for 5 months, because you're
Yes.
going to have to schedule a meeting for, after 5 months, because you're going to have to
Yeah.
give yourself a couple of weeks to have the conversation and then explain to the employee, okay, it's not working out, or it is let's be clear, 9 times out of 10, it is going to work out. So you passed your
Yeah.
probation, but then you've committed to that employee is committed to you after 5 months. But guess what? In less than 4 weeks, they're going to have full unfair dismissal rights. So you need to be clear at the end of that probationary period that they are going to have full unfair dismissal rights. So I think that is going to be a really interesting change. We talked about it before in our appraisal podcast, but I think this is going to now become the year, perhaps the decade of performance management.
Performance management. Yeah.
What, tell us what you think about that.
Yeah, yeah. Well, I mean, I've got a lot to say about that, but I just think one thing I would say is it's really important, even more so, to have very well defined objectives from day one,
Yeah, that's true.
to really help the effective onboarding. I think, let me give you an example. When I joined Adidas some years ago, I had a 3-month onboarding program. I know, but it felt heavy at the time, because my previous industries had been investment banking, and it was literally learn on the job. But it meant that I had the right tools, the right network, and the right support. I mean, I do believe this is a bit of an outlier compared to other organizations, because really most of my career I've been kind of learning by the seat of your pants, learning on the job, and kind of being much more agile. But I think that's really important. But yes, this is the year of managers having to step up with performance focus, not the annual form, but real conversations early on with auditable notes. And this is where I think HR can really help and facilitate. The law is saying, don't wait, don't hope, don't drift, basically, I think.
Yes, great
So
summer.
yes, exactly. And I can also imagine, though, this is putting leaders in a slightly worrying place, potentially making them anxious about, well, what if I hire the wrong person? But on the opposite side, I think employees will feel safer earlier, but also more scrutinized. So I think there's a bit of balance here as well. But I think that era of let's see how it goes is totally over.
It's gone.
Kindness without clarity is now organizational risk, I think.
Yeah,
So
that's a great summary. And I posted on LinkedIn that, the older I've got, the more I know that the most important law in life is the law of unintended consequences.
yeah,
Perhaps that's a slightly jaundiced, maybe even mature view for someone in their middle years, but it is true. And one of the consequences of this could be to accelerate dismissals, to your point, because the view of waiting and seeing, that basically ended on the 16th of December last year. This is going to come into effect, and it is going to accelerate those performance discussions. Effectively, they're required from day one now, certainly no more than a month. And the point you make about objective setting, I think, is a really, really good one, because I've moved around a bit before setting up Consign Law, and I've moved into some bigger firms, some smaller firms. But it's really interesting. They spend months and months and months hiring you,
yeah.
working out what your book is. Are you the right person? When you join, there's no objective setting at all. There's no role clarity, etc., etc. And so that bit, being clear to someone about what their objectives are and that they will be held to account, and that neither side, neither employer nor employee, can fudge this. I think that's a really key thing. So that increases the need for kind of
Yeah.
specificity of role and the role of HR.
But John, it doesn't set you up for success, that kind of scenario. And I mean, the ultimate, the kind of the echelon of what it should be is that during your interview process, of course, there are core competencies that you're evaluated on, but of course, you're never going to hit all of them.
No,
And that's where, from day one, you start your job. There should be a HR or development person coming in and saying, okay, these are the gaps that we think we need to bridge in your first year. These are some of the courses or the help or the mentorship that you're going to need. Now, this does not happen, but this is best practice because resources are low and no one has time and
yeah, they
everybody
don't.
wants everyone performing on the job. But that really is kind of casebook, great best practice. So, as we summarize, performance management is no longer a once a year type event. It's a risk management. It's about fairness, but it's also about leadership discipline. So, what can managers do right now? So, I think the first thing is, as you're hiring, be really clear about what you're expecting in this role, and be really clear about what's going to be expected from the first year. But as that individual starts, get issues on the record early, document performance and decisions, and definitely before the probation period expires. But also having clear factual notes during your one-to-ones. One of the things that we talked about in our last podcast was the fact that there are a lot of individuals that don't get feedback,
Yeah,
only maybe once every 6 months. But, every check-in or how are you doing, what's happening, is a chance to give feedback. So I think having that is really important. And then I think the way I would summarize it, it is about coaching your employees now rather than ignoring or kind of ignoring the performance or what they're doing. It's about empathy rather than silence. It's about documenting patterns. That's really important, and not thinking only about emotions. So I would say this shouldn't be dramatic. There shouldn't be lots of judgment, but we need to make sure we're not being confused nice with being clear. Do you know what I mean?
it's become more important. There's two other aspects I want to talk about. That's a very good summary. Thank you. The the other point is that for higher earners, and you've worked in large banks in the past, you're now going to see the cap being removed for unfair
Yeah.
dismissal cases. Now, look, philosophically, I always thought it was always anomalous that there was that discrimination claims were uncapped and uh, claims for unfair dismissal were capped, when arguably the right to have a job is the foundation of everything. So that always struck me as a bit of an anomaly. But the effect of removing the cap could be massive in the city, because you are now going to see 7 or 8 figure unfair dismissal claims, which
Yeah.
is going to make it much more difficult for those to be compromised out. Because typically, if you work in the city, you'll get, you can have a protected conversation with someone and you'll say, well, we'll offer you, perhaps some bonus, your
Yeah.
notice, and a relatively small ex gratia figure, maybe 30, 50,000 or whatever, for your unfair dismissal claim.
Could be 1 year's, sorry, 1 month's salary, couldn't it, for the
For,
one
for,
year
for,
that they were?
for,
Yeah.
for, for the employee. Now
Yeah.
the employee is going to say, no, 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 I'm out of work. The country is in a bind and I could be out of work for 2 years. My earnings are £1 million a year, for example. And so I'm not settling for 30,000 or 50,000. I want £2 million, please. And my £2 million is calculated by 50% my, or maybe a third my, 1/3 my salary, my initial package, but 1/3 my bonus and 1/3 my deferred comp, my
Oh,
equity. So,
yeah.
so you see you're going to see a packaging up of unfair dismissal cases and accrued rights for accrued pension, etc. So you could see some very, very large unfair dismissal cases that make cases much more difficult to settle and much more likely to end up in tribunal. What do
Yeah.
you
And
what do you think that's going to do to the culture of city, not just hiring but firing?
well, who who knows for sure, but there's a few scenarios. One scenario is that we we roll back and we go back to people that we've worked with before, trusted individuals. Let's say clubs start, kind of old school clubs start kind of bringing their trusted colleagues and peers, and of course that has added conflicts in itself. But I think there'll be less of a willingness to take a risk and to hire somebody for their strengths, and for new areas of strengths that they bring, rather than just bringing someone who fits exactly the spec you're looking at. So that's one potential scenario. Another scenario is that there's a real fear about replacing or hiring external talent, and there'll be maybe a potential bigger focus on developing senior leaders internally. I have seen that in the last year or so anyway, I think because of the economy and the bit of the downturn, but there has been a real reluctance to take a punt externally on a big ticket hire. So I think we might see that also as a scenario. And I think the last thing is that it could create stagnation in organizations, but you will have a competing dynamic, which is this world of work, transformation, AI is really changing the way organizations are having to think. And what I'm seeing just in the last, I would say, 6 months, even
Yeah.
before kind of just before summer, I started to see a real need to bring in C-suites who have experience of transformation, acceleration, growth, but also digital transformation and being able to adopt AI for the future of the organization. There aren't that many people with that experience, but there's definitely a push to get those kind of qualities. So I can't see hiring shops closing altogether. I think it will continue, but I think there'll be more cautiousness about who's being hired.
Because the risk is now greater because of the removal of the cap. I want to talk to you about, look, my view is that despite all of these changes, we still have potentially the best employment law in the world. And I wanted just to get your internationalist perspective, because you've worked for a lot of large multinational organizations. I say that because we are not a red of tooth and claw American model. So they have no unfair dismissal rights in that country, and it is employment at will. Most people
Yeah.
don't have notice periods. Arguably, philosophically, that makes an economy more competitive, because if you don't have a notice period, you're compelled to get a job next week. There's no employment protection. There is some discrimination protection, but
Yeah.
there's no unfair dismissal right.
Yeah.
The so we don't have the red of tooth and claw American model, but neither do we have the kind of socialistic, more protectionist European model. You've hired and run organizations throughout EMEA. How do you think that our employment law benchmarks against, say, France, Germany, other jurisdictions?
Well, this really depends, John, on which side you're talking from, which
Yeah,
perspective. From an employee perspective, I think UK employees would start to feel a little bit more safer,
protected. Yeah,
but yeah, a little bit more safer, but certainly nowhere near the level of European counterparts. If we think about Germany, we think about Holland, we think about France, very strong employment protections and workers' unions and workers' rights. So I think that is, and if we look at the extreme, which is the US and also some parts of Asia, that is, seen as it's quite cutthroat, and it is very difficult. So you have very few protections, but you're also paid better in the US, and there are much bigger discrimination opportunities, put it that way. Um, on the other side, from an employer perspective, I think I think the UK is coming somewhere in a little bit more of a, I would say, somewhere in between the
yeah.
two. I think it's a good balance for now. I do think there were some things that were absolutely needed. I think, a bigger focus on sexual discrimination as a result of the EBA's new ruling, I think is really important. And other topics that we're going to discuss, zero hours contracts. I think those are really important topics as well, given our demographic in the UK and also some of the nuances of the UK. So, yeah, I think we're somewhere in between, but it really depends which lens you're looking from.
Yeah, I mean, look, I think it is still going to be possible, if you follow the right processes, and that's the theme of this podcast, to hire and fire respectfully and properly, and we would encourage all listeners to do that. Look, one of the things that I did want to talk about towards the end now is the BIS, the effectively um, government organisation which assessed the whole cost of the Employment Rights Bill, now the Employment Rights Act, scored the near abolition of 0 hours contracts as the
Yeah.
single costliest thing. That was before the introduction of the 6 months, but that still might be the position. And there are some smaller changes that are not going to be on the front page of the press in the way that the unfair dismissal rights changes were, that are pretty significant. So the near abolition of the ability to hire and rehire, fire and rehire, is going to make it very, very difficult to implement contractual changes effective the beginning of January 2027. And what everyone thinks about that, some people think the government have overreacted to the P&O fiasco, etc. But you in the past, as a leading HR practitioner, will have used contracts to change important contractual terms. And ultimately, if you try to change my contractual term, and you said, well, Hayes, you must accept this, or else I'm going to give you notice and issue with a new contract, it's going to be virtually impossible to do that, because that will constitute an unfair dismissal claim. So that might make implementing contractual changes, whether those are pay changes, changes to benefits, changes to restrictive covenants, my area, those are going to make those changes more difficult. So there will be less flexibility
Yeah.
there.
Yeah. Yeah. And all of those changes, if you think about in a European context, would already have to be consulted
Yes.
and agreed with the workers' unions anyway. So we're kind of, yeah, leaning more on towards that side in a way. Yes.
I agree. And so it is a more collectivist way of doing things.
Yeah.
And possibly the biggest change, but it's still subject to a lot of regulations. We wanted to leave it at the end of this podcast, because this is the really committed listeners will still be listening. And it is the near abolition of 0 hours contracts, and the fact that it is going to make it shift patterns predictable and necessary, and the government confirmed that agency workers are brought into this. Now,
Yeah.
hitherto, we have had by a long way the most flexible labour market in what was the old EU. There are more agency workers will have got up and gone to work today than in the rest of Europe
Exactly.
combined. So it would be a great shame if, as a result of these changes, it resulted in the reduction in flexibility, particularly because a lot of these agency workers are underrepresented classes. So
Right.
that there are
And
lots of
that's right.
there are lots of agency nurses, for example, who happen to be substantive nurses of the NHS, but they use agency work to top up their pay.
Yeah.
And I certainly have a lot of clients in that sector, and and a lot of younger workers who do shift work
That's right.
in pubs. Often our first ever job, we're 18, 19, we're getting a job. But if the pub is now saying, well, because Hayes worked 12 hours last month, you've got to give him 12 hours next month, and it may not suit the pub to do that, in
Yeah.
which case
Yeah.
they're not going to offer Hayes the job in the first place. And that would be a real shame and a real challenge to the UK economy. So if anyone else other than HR practitioners and lawyers are listening to this, like the government, etc., it is still subject to regulations, and they're subject to consultations. We mustn't overregulate the 0 hours and agency worker environment. Yes, people are entitled to more protection and
Yeah.
security, but if the effect of these changes is to mean that we have youth unemployment similar to that, for example, in Spain, where it's massive because they have a more restrictive
Yeah.
economy, and I think people are already finding that. Anyone who's got a child aged, 21 to 24 now is going to know that it's really difficult leaving university. Everyone I talk to, my peers, their children are doing
Yeah.
panic MAs because
Yeah.
they can't get jobs.
Yeah.
And
No. Yeah. I think the thing you've summed it up really well. I think there's a massive impact on sectors like hospitality, logistics, care, retail, construction, and so on. And I think We should be honest though, some business models were built on uncertainty being transferred to workers though, John.
Good,
You've
good
also
point.
got to
Yeah, yeah.
accept that. And I guess this is what's been challenged with this part of the act. So it will increase cost and complexity in the short term and make business planning it's going to have to be less operational and more strategic. But
Yes.
I think the key thing is business models will need to be redesigned. So I think that fear of rigidity in a volatile demand is definitely what employers are thinking about. And I think managers are, oh, how am I going to cover shifts now? But I think this is the opportunity that's important here. This is the moment to actually stop treating workforce planning like an admin task and actually treating it like a strategic capability. So I think some answers to this would be having more hybrid contracts, looking more at internal talent pools, multi-skilling, looking at scheduling technology, for instance, and having real honest conversations with unions and workers. Not all the solutions, but just some to start thinking about.
I think you're right. I think the planning is the key on that. Again, more role I think for HR and probably management, because often businesses would resort to, it's almost like a bat phone, which is fine, agency workers, because they haven't thought to plan. So you need someone for that immediate shift. There hasn't been the resource planning. There hasn't been the pre-thought to think, okay, how am I going to manage this shift in the days to come, or the weeks to come? So I
That's
think
it.
that as well will be more of a challenge for employers, because it's going to make the engagement of 0 hours workers and agency workers more challenging.
And dared I say, John, in a very wry way, I think the organizations that are going to win in 2027 are not the ones with the best lawyers, but the ones with the best leaders and managers. And I think that's where HR plays a crucial role for from now on till next year.
I agree at least with 50% of that observation. And although, of course, great lawyers are also extremely essential to the UK economy, as anyone would recognise. But yes, I do.
Touche.
I do agree with that. And look, with that expert put down by my co-host, we're going to conclude this the podcast. Thank you very much for listening. There are lots more changes afoot in the Employment Rights Act. We can update later in the year. And I hope you all have a good January. Take care.
Thank you. Bye bye.
Bye.